from supplementary causes, item number 1 for pronouncement of judgments.
In view of the discussion now, this writ petition is devoid of merit. It is dismissed with cost of ₹10,000 to be paid to the Shillong Bar Association. The proof of deposit of cost be filed before the registry within 30 days. Now, your earlier writ petition was amended and your termination order was challenged there. But then there is no disclosure of that in writ petition number 347. The government also will not disclose all those things. This is something, this amounts to suppression of material. Your earlier writ petition of 2005, it was amended in 2000. But then at the argument, it was argued that the act of termination was not known to you. They said government has, the document which the government brought in, it was new. This is wrong, totally wrong.
Any mention?
Yes.
Actually, we need some more time to do research and prepare in this case.
What research is needed here? What is this matter?
11.
Lordship, actually, the senior counsel.
Okay, you are mentioning on behalf
Behalf of the petitioner.
item 11.
Yes, Your Lordship.
Yes.
Lokayukta matter, Lordship.
How long you want?
Lordship, 2 weeks.
Problem.
2 weeks.
Much obliged, Your Lordship.
May it please, Your Lordship, I beg to mention item 15. 1-5. I pray for 2 weeks' time, Your Lordship.
I have no objection, Your Lordship.
Same order.
Much obliged, Your Lordship.
2 weeks.
Lordship, I beg to mention item number 4, Lordship, on behalf of R. Mazumdar, his indisposed, Lordship.
No objection, Your Lordship.
Yes. When do you want it?
After a week, Lordship. After a week.
After a week. Here he will be all right after a week.
As instructed, Lordship.
2 weeks, Lordship. Like then again you come for again after
2 weeks, Lordship. Let it 2 weeks.
Take some so that he recovers and then do not have to renew this. This is also same.
May it please, Lordship. Lordship, I beg to make a mention of item number 12, Your Lordship. Your Lordship, I pray if this matter is taken up after 2 weeks, Your Lordship.
I have a 1.3 matter.
And the request made on behalf of Mr. Dr. N. Mojikan, honest GSG pen for the petitioner. This is matter after 2 weeks. 2 weeks.
2 weeks.
Yes.
Much obliged.
Mention item number 16, Your Lordship, of the main. Item number 16. I'm the petitioner, Your Lordship.
Who's the other side?
Other side is Mr. Sheikh is there, and then Mr. Paske is also there.
Yes. What is the matter about?
This is quashing petition, Lordship.
Washing off?
Yeah, first they have.
Quashing of, initially, when we filed the criminal petition, it was just an FR. There was a reinvestigation which was allowed, and then reopened. And then now, during the proceeding of this particular case before Your Lordship, the matter has been charge sheeted. So that fact has also been brought by an additional affidavit, Your Lordship. So it's fixed for hearing, Lordship.
Okay. When do you want it?
1 week, Your Lordship.
Let it be 2 weeks then, Lordship. Let 2 weeks.
It's on the request. Yeah. Yes.
I am appearing for the private respondent.
Pleasure.
Yes. Record. Yes.
Pleasure.
I beg to mention item 14, Your Lordship. I've taken the consent of the other party. It's a joint request, Your Lordship.
On the joint prayer.
Yes, Your Lordship.
Okay, on the joint prayer made by the parties. When?
After 2 weeks, Your Lordship.
List after 2 weeks. Item 14. Yes.
Your Lordship.
So I'd like to make a mention for item 5, Lordship.
Yes.
Lordship, I'm praying for weeks time, Lordship, this matter.
How?
2 weeks.
2 weeks. Let it be 3 weeks then, Your Lordship.
3 weeks.
Let it be 3 weeks.
Make 3 weeks on the request made on the list after 3 weeks. Yes.
Obliged.
So I have similar prayer for item 6 as well, Lordship.
Item 6, who is the other side?
Lordship.
Yes.
From 2 weeks time, Lordship.
Who is the other side? 2 weeks. Yes.
Your Lordship, I'd like to mention item 3, Your Lordship. 3, Your Lordship.
Yes. This is an RR colony matter. Yes. Yes. What happened?
Lordship, I'm praying some time, Your Lordship, in this matter.
2015 matter.
Your Lordship, there are some annexes where we need to consult with the petitioner herein. So I'm
Annexes are already there. What consultation?
Your
will be?
Lordship, we just need some clarification.
In fact, Lordship, if you recollect on the last date, my friend, the private respondent, had given the copy way back in July last year,
Okay.
affidavit.
Yes.
And
They never took over after allotment was made.
yes, no, then on the last date, he has sought for time that, in spite of the fact that the copy was given in July, he said, I have not gone through it. And he said, positively by this date, he'll go through it and come and apprise the court. So we are hold up at that level. Only thing is, Lordship, is not that we are opposing the adjournment. Only thing is, this Lordship has heard and taken,
No, their
kind of
issue
the-
otherwise is
very, very,
complicated here.
very, very simple.
But
Lordship,
fact remains
absolutely.
that allotment was made and it was never been acted.
Never been done. And then my friend from
That is what
the
Mr. Lindo's.
Lingdos,
affidavit
he's produced a document to show there was
says.
nothing
Then
as
what
such.
remains there?
Nothing.
If
Your
you do
Lordship,
not
I'm just
take over, then no right will be accrued to you. You will not. No right will accrue to you.
If there are personal difficulties, no issue, Your Lordship, but at
I
least
understand, but then Mr. Khan, this is 2015 matter. You see,
absolutely.
normally this court accommodates lawyer. You
Yes.
can understand that.
We understand that.
But then this
2015 Lordship and Lordship, keeping a matter sometimes parted for a long time, then again we have to do the re-hearing. Supposing some issue comes back
it
again.
happens in most of the
Most of the cases, yes.
we have to do hearing for
Exactly.
many occasions. When can you see, madam? You take just take time and make sure that the next time you finish it.
Your Lordship, I'm praying for 2 weeks.
Up to you. Then.
Okay, just make it 2 weeks. Yes.
Obliged.
Your Lordship, I beg to mention item number 8 and 9. It's a connected matters, and I beg to take up this matter after 2 weeks, Your Lordship.
Yes. These are all quashing matters.
My lord.
Involving what crime?
My lord. Juvenile justice, my lord.
Juvenile justice.
My lord. My lord, they are agreed by, my lord, the conviction, my lord. I think so.
Conviction.
My lord, yes. There is an order, my lord, 29/9/2022, my lord.
Yes. Conviction under what act? Under what section of law?
Under POCSO, my lord.
And the accused is juvenile.
My lord.
Okay. Same order. Just say. When you want it?
After 2 weeks, my lordship.
Yes. 8 and 9. Same order.
Item number 8 and 9.
Yes.
Obliged, lordship.
May it please your lordship. Lordship, I beg to mention item number 10. Conducting counsel Mr. SN has some personal difficulty, my lord. This matter may kindly be taken up after 2 weeks.
This is that matter which has been substantially heard. Only left is circulation.
What was as hard is for?
We will assist, my lord. Well, only thing left here was to circulate certain judgments on
compliance of 202 and
202. Then now, lordship, a very interesting point was asked whether non-compliance of 204 will also lead to dismissal of or quashing of the entire. So I have certain judgments, my lord. The only thing left is circulation of certain judgments, and of course to refresh, my lord, also because the matters.
You will have to refresh. Most of the thing court has forgotten.
My lord,
except for that issue that.
We will assist, my lord.
Okay. On the request made on behalf of the learned counsel for the respondent, and is this matter after 2 weeks?
Obliged.
From the main list, item number 1.
My lord, 145 proceeding was disposed of by the learned executive magistrate in Tura, my lord. So first, I have challenged this that there is no materials to support the 145 proceeding, my lord. But I will not go into detail that part, my lord. Only this, the order says that the learned trial court, despite its effort at reducing evidence and examining the record, could not come to a conclusion as to who is in possession. Therefore, the learned magistrate attached the land.
Why this application is before this court? Why you did not approach session judge?
Well, this order was passed by the additional
145 proceeding. So definitely this revision would lie before session judge first, isn't it?
Yes, my lord. Good.
See,
but this is the concurrent power of the revision, my lord, to the High Court as well as Sessions Court.
You are losing. See, either of the parties will lose one forum. That is the problem.
So, my lord, I don't want any relief in this regard, my lord. I want to confine myself only to one point, my lord. That the learned executive magistrate had directed that let there be demarcation with the district council. I also support that, my only thing, but this order was passed in 22 and till date demarcation has not been made. So if your lordship can pass an order just fixing a time limit.
Can that order be passed in 145 proceeding?
So, but it has already been passed, so we'll have to go into that detail that whether the powers of 145 is available to pass such an order. But he has passed, rightly or wrongly, an order has been passed, my lord. So let it be demarcated, as the London magistrate has come to conclusion.
No, if it is wrongly part, then what? Then you do not challenge this order. This court will not give any seal of approval to any wrong order.
So otherwise, this is not a fit case for 145 proceeding, my lord, because there is not even a whisper of apprehension of breach of peace in the entire proceeding. Neither by the witnesses.
What is the order? Where is the impugn order? Where is the impugn order?
Last, my lord, last election. Registered 3 is the impugn order.
Yes.
My lord, it starts at page 23, last paragraph, my lord. The effective part. Page 23.
Yes.
Last paragraph.
Who is appearing for the other side? Who is appearing for the respondent?
I am appearing for the respondent, your lordship.
Okay. Yes. Yes,
so, my lord, it reads as follows: on perusal of the documents placed before me by both the parties and on careful consideration of the same, it is observed that the first party, in support of their claim, produced patta copy of the complaint letter dated 1/9/2003, document executed by Watrin Marak, judgment and order dated 21/2/20, passed by the Learned Court of Land Revenue, Ghat District Council Tura, which issued directions for demarcation of land, clearly proving this, that there was an attempt by the opposite party to dispose the land in a sustained manner. The latest instance being to set up shops. Then, my lord, next page. However, judgment order dated such and such passed by the taking cognizance of the matter that there exists certain dispute. However, the parties, as to what the next paragraph, my lord, says both the parties have been unable to prove the extent of boundaries of the land from land documents produced by them or through witnesses. I am unable to satisfy myself as to which of the parties are in actual possession of the part or parcel of the land covered by such and such a patta. It is a fit case to do a proceeding under section 146 CRPC and attains the land until demarcation of boundaries in compliance of judgment dated such and such. Hence, I draw proceeding under 146 CRPC and attains the aforesaid subject land. None of the parties shall engage in any economic activity on land during the period of attachment or until such time when process of demarcation is finally completed. An officer in charge of Ampati station is appointed as receiver under section 146(2) CRPC. So, my lord, of only one sentence that how much time it should be given to the district council to demarcate the land. That will
What?
serve
How
the
long?
purpose.
How long order passed under 145 remains valid? What is the duration?
But there is no such limitation. Just like 144, there is certain time limit. There is in 107 also there is some time limit. But 146 there is no such time limit.
146 there is no stamp time limit. It means.
But yes,
See, you first of
107 and
all, this order was made on the basis of the documentary evidence. Can it be done in a
Yes,
140
madam.
proceeding?
That is
140
the thing, my lord.
proceeding has
It
to
should
be without any right of ownership. It is only the possessor.
Yes.
That
Yes,
is what. And this entire order is based on the documentary this thing evidence. And what's
Yes.
order of
Then it
20?
takes,
What is that order? Judgment order of 2020. What is that order?
I'm not a party there, my lord, my lord. It is the respondent who had initiated that proceeding.
Now, what is
Your
this order
Lordship,
and
he
which
was a
author?
party, the petitioner was a party there. He was a party to that proceedings. But he has not brought it before this honorable court. Here the patta of the petitioner was cancelled. And the same order was not challenged by the petitioner as well.
It's okay, but then what do we have to do with all those facts in a 145 proceedings?
That is the matter, my lord. It cannot be taken into account. This is not
There
a
is
fit case for
the
145.
order doesn't say that there is any apprehension of breach of peace.
Yes.
It
does
has
not
to be a boundary dispute or land dispute coupled with apprehension of breach of peace. If it is not there, then any order passed under 145 will go. It will not remain.
Your Lordship, there was breach of peace. That's why an FIR was filed. And to that
But then
effect,
where is it? Where is that finding recorded? Where is that finding recorded?
No such finding is there, my lord.
Yes, this order cannot stand.
In review of the matter, this 145 proceeding will not stand, my lord.
Your Lordship
This order,
at page
this very
19,
order. See, this very order has not the executive magistrate has not recorded any case of emergency here. 146 order can be passed only after proof of existence of emergency situation. It is not there. No. When this order was passed?
This order was passed on 20th April 2022. 20th of April 2020.
None of the parties have approached the magistrate for withdrawal of the attachment.
No, my lord.
Your Lordship, actually, it was for the demarcation where the petitioner is not allowing the district council to demarcate the land.
How can order of demarcation be passed in a proceeding under 145?
That has been passed in compliance of the previous order, Your Lordship.
Whatever it is, but then it is an exercise of jurisdiction under 145 when in compliance of earlier order means compliance of which order? Who passed which are the passing order? Who is the authority who passed the order? The earlier order, if you say earlier order, that means the order passed by?
By district council, Your Lordship. Yes.
So is the magistrate executing authority of district council order? Mr. Siddiqui, is there any stipulation how long an order passed under 145 shall remain valid?
My lord, no such 30 days.
Like 107,
There
that
is
is
no time limit.
107 CRPC, it is
107
there.
is there, 144 is there. 107 says 6 months, my lord.
But then
144 also says 60 days. But 145, there is no time limit.
You are first party or you are second party?
I'm the second party, my lord. Here.
What is the order during proceeding under 145, Mr. Siddiqui? What is the initial order of withdrawal of proceeding?
It is not there, my lord. Record was called, my lord. It may be in the record.
What is the challenge? You have not challenged anything. You see, like, there are certain prerequisites for withdrawal of proceeding under 145.
My lord, I am saying that in the entire proceeding is illegal because there is no whisper of any apprehension of breach of peace, my lord. There is nothing, neither by evidence nor by the finding of the court.
So that is why, see, perusal of the initial order is required. Because even the withdrawal of proceeding under 145 requires that there has to be a report of apprehension of breach of peace. Magistrate required to record it, and thereafter. So if those materials are not there, how can we decide this matter?
But then, if the record is called, my lord, we will obtain the certified copies from the record and submit to the next. That can be done only.
No, you have to obtain it from there. Why this record should be called just to create an opportunity for you to take certified copy from here? It was your duty. You should have obtained it, procured it. If your contention is that there's nowhere it is reflected in the record that there is a breach of apprehension of peace, then
yes, sir.
Apprehension of breach of peace, then in such a case it was your duty. Yet, Mr. Pasque, what is your thing?
Yes.
What do you say?
Your Lordship, there was apprehension in the sense like I had gone through the documents when it says, but it's not been attached here. So it says that the petitioner herein brought in people and they were like, they were encroaching the land and then
But then
taking.
If it is not a part of record, how those facts will be taken into consideration? Law requires that all those has to be reflected in the proceedings. Where are those?
Your Lordship, the only prayer that I would seek that a redemarcation may be carried out.
We cannot do it. If this order is illegal, how can we do it? For getting the matter demarcated, you initiate other process. How this proceeding has been done, this entire proceeding should have been paused. This is the main thing. It's not only the order. This entire thing has been given a total go by the requirement of law. You have not challenged the proceedings, Mr. Siddiqui. You have only challenged the impugned order.
Yes, ma'am. We have said, my lord, to quash the
See,
proceeding under
where
section
is it that?
145
Where
of
is
the
that? See 145 sub clause 1. See,
Yes.
was there any compliance of that? There is no police report annexed with your petition.
No, my lord, it is not there.
You have not annexed anything, only except the impugned order, nothing is there. Heard, Mr. Siddiqui, London Senior Counsel for the petitioner. Announcement here first. London Counsel. You can for the sole respondent. Divakara. The effects and as can be revealed from the materials on record is that the respondent herein has filed an FIR dated 5/2/2021 to the officer in charge of Ampati station, alleging that the petitioner was attempting to forcibly occupy her land situated at Ichakuri. What is that? Where is that Ichakuri, Mr. Siddiqui?
It is within Ampati, my lord.
Southwest Garo Hills, Your Lordship.
Nothing, only Ishakuri is written. Nothing is there.
It is within that Ampati police station.
Did we say FIR was lost in the Ampati police station?
Yes, sir.
Okay. That's it. Ishakuri, Ampati, South Garo Hills district. Southwest Garo Hills. Is it correct?
Southwest. Yes, ma'am. Southwest Garo.
It appears that pursuant to the lodging of the FIR, the police conducted an investigation in the matter and thereafter forwarded a report to the court of the executive magistrate, Southwest Garo Hills, for initiation of proceeding under section 145 CRPC against both the petitioner and the respondent herein. The Learned Executive Magistrate, South Garo Hills, consequent upon receiving the police report, has drawn up a proceeding under section 145 CRPC under section 145 CRPC. What is the case number, Mr. Siddiqui? Is it miss case number 1 of 2021?
Yes, Lord.
Nothing, there is nothing. Everything is done a very haphazard way, you see. There is nothing, no statement in your petition that this after receipt of the police report, how the matter was initiated, by what registering what case. How can it be a miss case? It has to be a CR case.
Yes, my lord. Later this case.
What is the what's the last name? Drew up a proceeding under section 145 CRPC in MISC case, MISC of CASC number 01/2021. Full stop. It appears that pursuant to the withdrawal of the proceeding and filing of written statement by the respective parties, the learned executive magistrate by impugned order 24/2022 passed an order directing directing what we said by the impugned order. First order directing attachment of the land in question under section 146 within bracket 1 CRPC and prohibited the parties from engaging in any economic activity on the land during the period of attachment or until such time when process of demarcation is completed by the concerned official of district council.
Yes, my lord. Demarcation with the district council. Yes, my lord. Demarcation.
Demarcation to be conducted by the concerned official of district council, isn't it?
Yes, yes, my lord.
By the Land and Revenue Department, District Council.
Yes. Yes. What is it? Till the completion of the process of demarcation by the concerned official of the Garo Hills Autonomous District Council. Paragraph. Assailing the impugned order dated. Assailing the impugned order dated 24/2022. The learned senior counsel for the petitioner submits that the learned executive magistrate have not followed the provisions of law as laid down in section 145 and section 146 within bracket 1 of CRPC, and pass the impugned order without even recording that there exists a chance of peace over the possession of land in question. he submits that in absence of compliance of the mandatory provision of law, the impugned order passed cannot be sustained and liable to be suicide. And first, stop. Give a paragraph. Mr. E.R. Paske, Honored Counsel for the appearing for the respondent submits that this proceeding was initiated on the basis of the report of apprehension of breach of trust.
Your Lordship, my Lordship, may kindly.
Yes.
The report had mentioned, Your Lordship, that the parties are showing aggressive nature.
So we are saying that that is our submission. We are recording it. We are saying that there are apprehension of breach of peace. That is your case, isn't it?
Absolutely, Your Lordship.
Yes. So, what is the last line? You just allow the court to complete the line and then you just say, huh?
My apologies, Your Lordship.
Report of the apprehension of breach of peace filed by the police, which was taken cognizance of by the executive magistrate. Further submits that the order to attach the land has been warranted. For the reason of passing of earlier order. Adding an order dated 21/02/2020 concerning boundary dispute between the parties passed by the competent authority of the GHDC. He submits that taking into consideration effectual background, the impugned order does not suffer from any illegality, and this revision and this instant revision petition deserve to be dismissed. Here paragraph. Upon consideration of the submission made by the rival counsels and the perusal of the materials on record, it is found that the learned executive magistrate purposing the impugned order did not record his satisfaction to the existence of any situation concerning breach of is between the party over the possession of land in question. Further, the learned magistrate, before passing an order of section 1 CRPC, has also not recorded in the existence of any emergent situation of the matter. Which required the land to be attachment, land to be attached to prevent occurrence of breach of peace between the parties. The perusal of the impine order makes it further order shows do not say makes it shows that the learned executive magistrate has given much weightage to the production of documentary evidence in relation to the claim of ownership of the parties. Rather than going for determining which party was in possession of the disputed land. Is there any finding recorded by the magistrate with regard to the possession? Who is in possession, Mr. Siddiqui?
He says, I cannot find out who is to.
What it says? What is the part?
Last part. See, both the parties have been unable to prove the extent of boundaries of their and documents produced by them on through witnesses. I am unable to satisfy myself as to which of the parties are in actual possession or part of procedure.
Give a paragraph. For withdrawal of proceeding under section 145 CRPC. Give a paragraph. For withdrawal of a proceeding under section 145 CRPC and passing of a valid order under section 146 within bracket 1 CRPC, law require that there must be existence of a situation where a dispute with regard to possession is coupled with the existence of breach of occurrence of breach of peace in the area. A careful scrutiny of the impugned order doesn't show that the executive magistrate has recorded existence of any such situation by which it was apprehended that there might be occurrence of breach of peace due to the dispute of possession over the disputed. In absence of any such finding, the impugned order cannot be sustained. Give a paragraph. You say accordingly. The impugned order dated 24/20, then 04/2022, 2020/04/2022, passed in Miss Case number 01/2021 under section 1 CRPC. Is set aside and cost. The revision petition stands. Yes. There may be some correction here and there, Sasiji. So, yes. Call the next.
Item number 13.